Okay, good evening once more.
Good evening, sir.
Yeah,
You're welcome, sir.
Good evening, sir.
yes. Good evening, everyone. So, can you see my slide?
Very well, sir. We can see it.
Yes, sir.
Okay, all right. So, my name is Simon. I'm one of the lecturers in the course. My senior colleague, uh, Mr. Broduku, had taken the lectures with you before. And um, based on the feedback that is on the platform, 1 minute, let me check. Yeah, based on the information on the platform, he has taken you guys vehicles for doing business. That is sole proprietorship, partnership, incorporation, limited liability companies, and one man company. He also treated agency concept, you know, as well as legislation and forms of business legislation or regulated businesses. So this afternoon we'll proceed. I mean, this evening we'll proceed from there to another topic, which is law of contracts. And of course, it is not in doubt that as business person, this master's in business administration, as businessmen and women, you go into interaction every day. That is, you have cause to deal with someone. I mean, somebody. I mean, every day, be it on the line of business, be it on the line of social gathering, be it the line of family gathering, be it the line of office, be it the line of you know friends, as the case may be. You know, um, now of course, in every of this relationship, there's always an element of consent. There's always an element of consent. So even for those that are working, or for even employers in our midst, the element of consent is there. So you can't just impose yourself on the employer unless there's consent, and vice versa. You go on the line of either supply, buying and selling. There's always element of consent. Now, so of course, even in social life, in families, there are series of agreements. Even among you, the mates, there's even as I was telling someone, that even in this class, there are some people that you will enter agreement with, you know, by way of, oh, I will not be in class today. Please take notes. And when I come back, you just teach me what the person was saying, things like that. So what am I saying? I'm saying that agreement is just a fundamental part of life. There's virtually nothing we can do, you know, in the business world or beyond the business world without agreement, between the parties. Now, of course, um, you also have cause to deal with so many disciplines. You have cause to deal with accountants, have cause to deal with, you know, business managers, insurance scientists, you know, financial experts and all of those ones. And of course, you also have course to do with law. I mean, lawyers. So we are looking at this evening. You are looking at this aspect of agreement from the side of law. And one thing which you have to take note of is that what we ordinarily appear to be wide, you know, in the context of law, is usually given a limited, conception. So we're looking at, you know, law of contracts as part of business law. When you say business law, it's just a big umbrella. So we're taking a portion of it, which is law of contracts, and that is the aspects that are coming here. Now, for us to start, um, we start with the question: what is contract? Now, just to be sure that you are seeing my slide, someone should read that. Someone should read what is displayed on the screen.
A contract is an agreement made between two or more persons, which the law will enforce. The
Great.
elements of a contract are offer, acceptance, consideration, and intention to create legal relations.
Yeah. So just note that the fifth one. Note the fifth one there is valid capacity. At least for those of you that are in class, take note that there's a fifth one by the Supreme Court. The fifth element of contract is valid capacity. Now, yeah, who is the class rep so that we can add the class rep as co-host?
It's me, Chinelo Mbanefo.
Chinelo Mbanefo. Are you the daughter of Justice Mbanefo?
Yes, sir.
Okay.
No, sir. No. Oh.
I don't understand. Why are you so quick?
I want to claim good things.
Oh, great. Don't worry. I will give good things. Now,
Thank you, sir.
yes. So I've added you as co-host so that you can help me to monitor the class where there's need.
All right, sir.
Yeah. So now, we're looking at law of contracts, and we want to know what is contract. And I think because law of contract, because Chinelo Mbanefo wants to run away. She wants to run away from having anything to do with law family. But then one thing about this class is that I don't know whether Prof informed you that once you are in this class, you are all lawyers.
He did not tell us so.
He didn't call you to bar?
No, sir.
Okay. So, one thing about the law profession is that it's not about going to university or going to law school. You are called to bar on that day that, you attend the bar, the call to bar, conference, and then the Chief Justice of Nigeria will pronounce on you that you are a lawyer. So if you graduate with first class at law school and on the day of the call to bar you are absent, they will not confer. You can't be a lawyer. You must wait for another time, another event day that they are doing call to bar, and if they allow you to join, that's when you become a lawyer. Right? So you may have first class, unlike the conventional university that university that when you even if you're not there, you can do convocation, you can go on, and then you get certificates. That doesn't apply to code to buy. You must be physically present. Right. So, I think I did that in 2006. I don't know how old I am now at the bar. But then by the powers that were conferred on me in 2006, I hereby confer on all of you that are in this class, confer on you that going forward you are all lawyers.
Thank you,
So
sir.
yes, so you are henceforth refers to our learned colleagues, barristers, senior advocate of Nigeria, justice. Just pick the one that suits your status. But you are no more ordinary person again, right? So you are lawyers. Because as lawyers, it means that you have to situate, I like the way the law library will be. Just so henceforth, just assume that, just take yourself in that position. So once you see me, once we're in this class, assume that you are all lawyers. And that is the perspective you're looking at you at yourselves. Even though, just to caution small, that every legal practitioner have a jurisdiction, has a geographical uh, area of practice. So I cannot practice in Ghana. I cannot practice in Cameroon. I cannot practice in neighboring countries. I must be called to buy in those countries. So what I mean is that I also limit your area of geographical area of your practice, which is you can only practice in my class. So don't practice outside the class. Let me caution
Okay,
before.
sir.
Let me caution you before someone will go to office tomorrow with wig and gown. Hey, it was
That's going
cold.
to be impersonation.
So let me just put that jurisdiction, geographical jurisdiction first. You can practice very well in my class, but please don't go to office and start introducing that you are a learning colleague and even in the at home. Don't practice. We don't practice law at home because the house will scatter. Don't
This
claim
my
rights.
lord.
Yes, don't claim fundamental right at home. You can't work. If you want peace. So I'm begging you. I don't know where you are before you start doing your fundamental right at home. Please, lawyers, be calm. So now we're looking at something that's very familiar, which is agreement. Agreement is something that um, even a Danfo, or even Okada man, they will tell you that agreement, na agreement. Someone ever sang a song like that. That agreement is agreement. Now, but we're not looking at law of agreement. We're looking at law of contract. But in defining contract, we say it is an agreement. you know so something should just occur to you. If you can just reflect a bit, you just begin to wonder if a contract is agreement. An agreement is well known. Anybody, when you say an agreement, even a small person, when you ask your younger ones at home, was it the agreement, they know that, oh, you are talking about two minds consenting over something. you know they know the meaning of, but we're not saying law agreement, we're looking at law of contract. But in defining contract, we say it is an agreement. It then means that there's usually something in a contract, there's just something in agreement to make the agreement a contract, such that if you take that away, then it becomes ordinary agreement. And if you go on in this definition, you end up by saying that, look, is that agreement which the law will enforce. That also tells you that, look, there are some agreement which the law will not enforce. So, in the context of our discussion, the context of our analysis, we're saying a contract is an agreement, of course, and that agreement is made between two or more parties, which the law will enforce. So, agreement by one way, just consents two minds coming together. Now, we're saying that agreement, which is between two or more persons, of course, the case may be, is that which the law enforce. And so, if you can reverse that, what you can get there is that, look, for there to be a contract, anytime you say there's a contract, it means there's agreement. But not all agreements are contracts. Let me take it again. For there to be a contract, there must be agreement, but not all agreements are contracts. So as we're going to see, there are two categories. One is commercial agreements. You have what they call commercial or business agreements, and then you have what is called social or domestic agreement. So in domestic agreement, for instance, agreement between uh, husband and wife. There's some husband that when the wife is pregnant about to deliver, they will promise the wife all heaven and earth by changing everything in the house, everything. Now the wife has given birth to. You're complaining about Tinubu government, Tinubu administration. You breach the contract. You told your children, study hard. I will take holiday. You ask your relation, go to school, I will send money. You didn't send money. So at that level, if the parents, sorry, if the children are to sue you. You know, some of you that are parents in this class, your children would have been suing you every day, you know, for breaching several contracts, you know. And then of course, friends, people invited you, wedding ceremony, party, birthday. You say you were promised that you were coming. Now they cook the rice, adding that you were coming, you didn't come. The rice is wasted, breach of contract. Can they sue you? You know, so even in this class, you have some agreement which you are breached with your classmates. Can they sue you? You know, so we see that those social agreements and all of those ones like that, the law just look at it as they're all just gentleman way of living. They're not intended. So, you know, any promise that a husband is making to a wife, or any promise that a wife is making to a husband, you know, they're all promises, they're all exchange of promise, they're all agreements, but in the eyes of law, they're not binding. That's why so many husbands can lie and go with it. They will just lie. Now, I'm not saying they're lying though, but I'm just saying that they will say something, they will not do it. But then the wife will not sue them in court, because if they sue, it's still husband and wife, and of course the intention is not to enforce that agreement, right? So the wives that are in the married people in the house, you know, we're exposing you now that if we're promising each other, we just in the eyes of law, you are just joking, you are all just playing, doing love, nothing serious about it. Now, but if you switch over from that social agreement or domestic agreement, and you come to the side of commercial or business agreement, right? It's a different ball game. The law presumes that, look, oh, you intend that it should be enforced. And so, if you have a wife, she has a shop or superstore, and as a husband, you go to that shop and you pick things from that, pick items that are selling, being sold from that store. You have to pay for it. In that one, it's a business setting. You can't say that, look, oh, the taught you law contract that husband and wife cannot know. If the setting is different. So all that go on in the business setting, you know, be it employment, supply and, you know, demand and supply and all of those things, services provided, consultancy provided, and all of those things, you know, they are commercial setting, they are business setting. And of course, such the law will always presume that they are to be enforced. Now, in addition to that, for and most fundamental is that that agreement, which is called contract, must pass a test, and that test is what they call elements of a valid contract. You know, you would have heard about you know, somebody that work in maybe in the NAVDAC and all of those things, or standard organization of Nigeria. You would have heard something about something is fake drug, fake this, and all of those ones. You know, if I may ask, what makes you feel that something is fake? What makes you feel that something is fake?
When it does not meet up to the stipulated standard.
Standards, exactly. So you see that. So there's always a requirement so once you measure it and it's below that, say, no, this cannot be, because if it should have all of those ones. So the elements, those elements that will be in something or in drug or item that you feel that's genuine, and if it's lacking, then you say it's fake. It's the same that apply to law of contract. So if in agreement have all these elements: offer, acceptance, consideration, intention to create legal relationship, and valid capacity. If you have these five elements, once in agreement have five elements, then that agreement is called contract, and it can be enforceable. It can be enforced. But if these elements are lacking, if for instance there's offer but there's no acceptance, there will be an agreement but it cannot enforce. Because it's not contract. So that's why it's very important for, as lawyers, to discuss about this element, and this is one of the core things that we're going to do in this class. So two things before I move on. Let me just say two things. Her Excellency, Banofo, are you listening? Are you listening to me?
Yes, sir.
So, as a senior colleague, one of your duties is that if I ask a question and your other learning colleagues are too busy to answer, then it's also one of your duties to provide the answer. I know,
Okay,
I
sir.
know, I know they gave you the mandate out of for the fact that you demonstrated capacity, you know, that you can do this thing, you can serve them. So yeah, big guys, big guys, big girls there, big ladies, guys, and all of them are there. So please, just to remind you, I know you know it's your duty, but just reminding you that's one. Secondly, the element of contracts. I also know, once you're a lawyer, that's the beauty of being a lawyer. Because when I was calling you to bar, no one objected. Nobody objected to that call to bar. You all accepted. I'm so happy. So, when you become a lawyer, so many things are presumed. The class is very quiet now. Now, there's a presumption that as lawyers, you know about this element, offer acceptance, you know about this element. Is there anybody that is not aware of this element before? Any colleagues?
Sir, please, we're not aware. We're not aware. We just signed the contract.
Ah, ah, Little colleagues. Okay, so just say that you've forgotten, so I should remind you. I think that will sound better. Because lawyers are learned. You know the meaning of saying you want someone is learned. You are not educated, though. Other people are educated. They go to school, but lawyers are learned. That's why a lawyer, if you ask a lawyer something he doesn't know, he will seek for adjournment, right? But don't do adjournment for me in my class. I don't give you one thing now. You say, okay, please, this question that you ask, I seek for adjournment. Don't do it. So, in view of the fact that we're all colleagues, that so as colleagues to share information together, I'll proceed. So look at this element one by one. Now, the first thing, remember that in every contract, or contractual relationship, look at it from the side of you. There's a contract between you and University of Lagos, and that contract is for you to comply with the rules, and then University will give you your certificate, MBA certificate. That's why you are even here this evening. So I'm representing the university based on the agreement that you sign with the university, that you perform your own duties. University also perform their own obligation. At the end of the semesters, university will now give you your certificate if you comply with all the requirements, if you meet all the requirements. Now you will see that before you are giving admission letter, so many things would have come into play. The university would have advertised, you would have seen it, or someone will see it and inform you, or they'll forward to you. Then you go and apply. You apply, and they will ask you to submit some documents, or they'll ask you to call you for interview. You would have done all of those one. University will give you admission letter. You also look at it. You either pray or do something, and then you also say you accept, and then you say pay school fees. You pay school fees, and then you start gathering, and then you know people, and then they say, okay, have a class. They'll give a timetable, and that's how we're here today. So it's a combination of many activities. Even where you're working or people you are employing, there's always that need. Oh, I'm looking for someone to employ. Oh, I'm looking for a job. You start that discussion. Even in terms of supply of goods or consultancy services, the same thing. Oh, I want someone to come help me, give me legal advice on this issue. Oh, I want someone to supply me this office furniture. Supply me this. Oh, I'm looking for a building to buy. Okay, I have an agent. So there's always a chain of activities. Now, it is in those chain of activities that as a lawyer, you're supposed to locate, offer, acceptance, consideration, intention, and valid capacity. Because if the chain of this relationship exists, but as a lawyer, you can't situate those things. Then as a business person, this class will not help you. And so the essence of this class is that look, you're able to know that look, at every stage of your business interaction, you should know when offer is made, when acceptance is made, where you can determine the intention and all of those things in that transaction without necessarily involving a third party. So it then means that because the offer will not come in a transaction and have a named offer and things like that, you require these keys, and this is what we're trying to you to go through here. As the saying goes, lawyers are social engineers. Social engineers. You know, as an engineer, for instance, let's say look at your mechanic engineer, for instance. When you take your car to mechanic, they will pick, ask you question, and then they'll start picking tools one by one. They'll pick that tool on the car. If that tool doesn't work, they'll drop it, pick another one. They will do many things until the car is fixed. The same thing happens when a client or someone come to you for legal advice or legal assistance. You know, when you narrate all of this transaction to you, so it's not left for you to go to the tools. That is the rules of law. You start picking, okay, based on what the law says, this aspect amount to an offer. Based on what the law says, this aspect amount to acceptance. Based on what the law says, you can be able to. So as a social engineer, you don't fix that problem which is going on between the parties. So despite the fact that a transaction could involve so many of those things, the issue, what you should notice is that every agreement, every contract starts with an offer. Offer is the beginning of every contract. But the problem is that because it will not write the name on his forehead for you to know that, oh, this is Mr. Offer. It means that it's you who is involved that should know it. So the question is, what is an offer? What is an offer? So someone should read the first paragraph.
A proposition made by one party offeror to another offeree indicating his willingness to be contractually bound on certain terms, provided that those terms are accepted by that other party.
Good. So I expect everybody's following me. Now, first of all, they are saying that it is a proposition. Proposition could be an expression, it could be a promise, it could be an undertaking, but you see that something is manifesting. Now, remember that everything about contract is giving consent. So, when you want to go into any transaction with any person, if you keep that within your heart, it didn't manifest in any way, there's no way that transaction can consummate. So even if you are attending the same place, you see your neighbor in the same church, you are sleeping in the same estate, you are together, but you never air out anything that is in your mind. Forget that kind of transaction can never consummate. So we're saying that offer is where the intention manifests. And remember that it's the beginning of every contract. It manifests by expression or proposition or a promise. So there's something that you say, that you do. Because this proposition, as we're going to see, a contract, if you look at classification of contract, one of them is express and implied. And of course, contract can be created by conduct, in writing, or orally. So what I mean is that this proposition that we're talking about here, this statement that you're talking about here, can be made in writing, can be orally. It can also be, by conduct. So if I have a warehouse and you enter my warehouse and you pick some items, even without discussing with me, you know that I will send you invoice. And if I send you invoice, you cannot be arguing that, look, did that discuss with you? Did that discuss the price for you? No. The mere fact that you enter and pick those things, which are displayed there for sale, implies that you want to buy, there's need. So that's one now. It could be that you just send someone orally, make that discussion, face-to-face discussion. Please, supply XYZ to me. Please, employ me. I'm employing you. There are many instances where people are employed. They started work before letter of appointments even will follow. Right. Orally. Or it could be that we're in the age of telephone now. It could be that you do that in writing. It could also be that could be that just make a phone call or send SMS or send email or send WhatsApp chat. So there are many ways of discussing now, or go to the way you want to communicate with that person. Many ways that you can do that. So we're saying that it's not manifesting. So we're saying that the first person that does that made that offer, made that proposition is known as the offeror, the person that initiated it. So it could be, as we're going to see, I will make that proposition, that statement to you. If you're not, it's not okay by you, you counter it. And me too, I will say no. You will say yes. So you see that sometimes this you keep exchanging until that time that look, everybody will agree and then you accept. So it is a proposition, it's a statement. That statement is made by one person. The person that made that statement first is the overall. That's the beginning of the discussion, overall. And the person to whom that offer is made is known as who? The offeree. And that go on to where we're saying at the beginning of, at the definition of contract, we define contract as agreement made between two or more persons. So they must be offeree and they must be offeror. Just as I was saying, the offeror is that person that makes that proposition to the another person known as the offeree. Now, we are saying that that proposition made by that party is saying something neat, is indicating something. Who can read it out?
An offer may be. Okay, someone else is trying to read.
An offer
No.
may be made expressly or implied from the conduct of a party.
On the same sentence, you're going too far. We're saying that the offeror has made a proposition to the offeree. Is it not so?
Yes, sir.
Now, that proposition is containing something. Now, that's what I'm saying. It's saying that is the offeror is indicating his willingness. Remember that one of the theories of contract is freedom of contract. Freedom. That is the agreement, the consent that each party gives must be willingly, must be voluntary. So if we force a party to enter into a contract with you, that cannot be enforced because that consent is not obtained freely or willingly. So is indicating that, for example, is indicating the willingness to enter into that contract, to be contractually bound. So is indicating that look, is bound by the terms as provided for in that offer. So as I said, they could be offer if the at least if even if you are not working, University of Lagos gave you offer for admission. You see that admission is what is containing some terms. And in this case, University of Lagos became the offeror. You are the offeree. Your name was inside there. And if you look at your admission letters, University of Lagos was expressing the willingness to be bound. To be bound. Bounding here is they will use that certificate that you apply for. They will use that certificate, provided on the terms, provided you accept the terms contained in that your letter of admission. So sometimes in another transaction, you might not have something like letter from University of Lagos. It might just be orally. Oh, supply me, 10 cars. I'll give you X amount. Or it could just be by conduct, as the case may be. So you see that the overall is the one indicating the willingness to be contractually bound. Now, provided the other party accept. Who is to accept? Who is to accept?
The offeree.
The offeree. Exactly. So it then means that because remember that what the proposition being made by the offeror is just what the offeror have in mind that is manifesting. So it means that if it is not manifested, if it doesn't show up, then of course there's no way that the offeree will know this is what is intended and then accept or reject. So based on this, as I said, it can be made orally, it can by conduct, or it can also be in writing. It can also be made to one person, it can be made to two persons, it will be made to a group of persons, it can also be made to the entire public. Now, so we're going to look at elements of an offer. Just as we have elements of contract, we also have elements of an offer. Of course, when you say elements, that there are certain things that you must see in expression, whether it is writing, whether it's by conduct or is orally. Certain it must pass some test. It must meet those requirements. It's only when those things are present that you can talk about having a valid offer. So, but before I come to that element of an offer, there's a case here, Kali versus Carbolic Smoke Bowl Company. Now, for every student of contract, it's a must know. You can't do law of contract without knowing this case. Aside from the we citing this case applied to so many other parts of the law of contracts, right from the beginning to the end. So it's a case that you must know. Initially when when the internet was not there, you have to go and start reading textbooks. But now you have internet, all those things on just your fingertips. So I will ask someone, let me just give you like 1 minute for you, all of you that are there, go online, you know, type this case on your phone, on your gadget that you're using there. Let me hear from you what exactly the case is all about. So I give 1 minute. Are we together? 1 minute, everybody should go Google it. Then we share it together. What you read, what exactly what your Google is saying about the case. So 1 minute. Okay.
Okay, sir.
Back. We're back. We're back. So we're starting with who? Who's anybody that live
Me,
with this?
sir.
Okay, go on.
Okay, so this is a 1892 case with the English courts, Palio versus Carbolic Smoke Ball Company. I think he put up an advertisement. So the Carbolic Smoke Ball Company put up an advertisement claiming that their product could prevent influenza. and offered £100 reward to anyone who used the products according to the instructions and still contracted the influenza. And the woman, Mrs. Carlio, she used it as the product was indicated on the product, but still got influenza. And there was £100 reward, which the company refused to pay. So the courts ruled in favor of Mrs. Carley because I think it brought up the unilateral contract. It was from the company to its users, end users, and she accepted. So there was an acceptance from her. She accepted to use the product, to use the products, which sort of considered like an acceptance of the offer. And by using the products, well, that was like an agreement. That was what made it a contract that bound both she and the organization that produced the product. Well, there was something I noticed about this case is consideration, and we haven't taught us about considerations. I cannot speak. I could not really understand what they spoke about inconvenience and consideration.
Exactly. Okay. Yeah. No problem. They just before it's just about the price. For every benefit you must pay a price. So the question could be, what price do you pay? And we'll come to that at the appropriate in the course of our lectures. Yes. So let me hear from another person. I think that was good. Let me hear from another person. Yes. Can I hear from another person? I want to hear from three persons. One, the governor has said it. Let's hear from another person. Or should I pick myself? Hello. Okay, let me choose as my spirit directs me. Okay. Olumide Aluko. Olumide Aluko. Olumide, Governor, please. So, are there some people just log in and disappear or what? I don't understand.
No, Olumide is online. He will still respond.
Yes, I saw him online. That's why I call. I saw the name is online. That's why I'm calling. He's not responding. That means he's not online. He just log in and he's doing something else.
Hello, sir. Can I come in, sir?
Yes. Okay. Yes.
All right.
Just Barrister who? Identify yourself now. Huh? You announce appearance properly.
Barrister Shubham, sir.
Okay. Of counsel.
All right, sir. So according to what I understand about the Carboni and Caliber, the smoke ball contract.
No. Call the case proper the way it is, so that you part on it, you master it.
Okay, Cali versus Carbolic Smoke Ball Company.
Exactly. So that you can master it.
All right, sir. So actually, they brought in an advert. They started with an advert. So the advert was saying that, okay, around when the flu was actually existing, and they said, okay, they can actually they have a treatment towards the flu. They have a antidote, or more like a vaccine towards the flu around that time. And okay, they made an advertisement and said that, okay, if this vaccine does not work, they would give a refund of £1,000 then. Was it 1,000? £1,000, if I'm correct. Am I correct, sir?
No, Google it now. Just Google it.
100.
£100. Sorry, £100. They made an offer that they'll give £100. So Kali actually made a purchase. She used it and she said it was not working. She discussed with her husband, and her husband said, "You know what? We're going to charge we're going to charge the Carbolic smoke ball to court." So they were dragged to court, and they made it clear that, okay, yes, they made an offer, and they said, okay, that was just an advertisement. That was what Carbolic smoke ball was like. They said, oh, it was just an advert, but the fact that they brought in a condition which states that they will be making a refund of 100 £100 if it doesn't work. That binds it as a contract, which they didn't know of.
Last person to receive comment, then we move.
Sir?
Isaiah Samuel Benga. Yeah.
Hello, sir. Sir, can I ask a question pertaining to this?
No, just add. What do you Google when you Google that case? What do you find?
What I find in it?
Yes.
Okay, what I found out is this: that when there is an advert or a promotional advert, is a contract, and like the college, there was a contract from the smoke ball company, which says if you use their product, which is a product that stops fluid, and you have the fluid, that you have a reward of £100. So the woman, the colleague, bought the product, used it, and had the fluid. So she was asking for the reward. But the company was arguing that it was just a mere statement. But the court ruled that no, you put out this word and it's a contract. And they said there's no contract because you didn't offer it. But the court ruled that she bought your product, that means she offered it. And it was like, okay, but there is no damage. He said, no, she had it. That means what you said happened. That means you have to reward her and she won. But can I ask a question?
Yes.
Pertaining to our present situation. So now, if we have a country like Nigeria, and during the last election, the INEC chairman and his spokespeople were going around the country on radio, on television, on social and print media, even chartered housing, and told every one of us that there's going to be live transmission and all that. And at the end of the day, there was a glitch. So the INEC, has INEC not broken the contract? And what was the consequences? And how did they try to remedy that? So again, if all our politicians during the campaigning and electioneering
How
period,
does that is not law of contract.
okay.
Even though
Okay.
the social contract is not, INEC is not representing, the social contract is between the government and the people that so the government and the society and the society. So people that you
Well,
put in
INEC
place.
is an agency, a part of the executive.
Not everything. Not everything in life has to do with contracts.
Okay.
Exactly. And then there's a difference between private law and public law.
Okay.
INEC, the relationship between you and INEC is public. The contract we're discussing is private.
Okay. Okay. Thank you, sir.
Yeah. So that you don't. So let me move on now. Even though there's
Sorry,
God's,
sir.
is that God's way?
Sorry, sir. Good evening, sir. This is Olumide Aluko. Sorry, I was trying to unmute, but I didn't know what happened to my system.
Okay, that's fine. No
Or
problem.
that. Yes, sir.
It's okay. Those there.
Hello,
You
sir.
raised.
Good evening, sir. Good evening, sir.
Yes, go on fast. So we can move on from this. Let me just explain so
Okay,
that we can move.
okay, sir. Please, that's this case study we are kind of treating. I look at a particular takeaway from that. Now, in the case of this Khalil and the case of Khalil versus Carbon Lake.
No, call it so that it will be part of you. Call it properly so that it will be part of you.
That is Khalil versus Carbolic Smoke Ball Company.
Exactly.
Yeah. So, what of a situation, sir? Whereby
What happened in that case? What happened in that case?
What happened in the case is that Carbolic Smoke Ball Company produced a product called Carbolic Smoke Ball, claiming it could prevent influenza. They
Yes.
advertise to everyone using a product, and they're still contracting. Some people, like anybody who contracted influenza after using the product as directed will receive £100
Yeah.
compensation.
Yeah.
So the plaintiff, which is Louisa Khalid, used the product as directed, but still contracted influenza. Now she claimed the £100 reward, but the company refused to pay. The court ultimately ruled in favor of Khalid, holding that the company's advertisement constituted a unilateral contract. So what I want to you to buttress here is this. What if in a situation whereby there's a contract, let's assume, for instance, you have maybe ACTM drug, where you have Amatem, you have the soft gel, and many more of them. And we know that the first dose we take, from the first time you take it, if you take first dose by 1 o'clock in the afternoon, you take another one by 8 o'clock, 8 hours interval. Now, what of if peradventure, maybe we have a kind of society that is somehow, maybe somebody violated, maybe because they want to probably claim maybe the money. What is the parameter to measure that Ms. Louisa Khalil take that drug according to the direction or the prescription or directive?
Yeah.
Because liberal.
So that we don't waste time on that, because that was already, there was no dispute about that. The company did not raise alarm that, oh, she lied, or she did not use it as prescribed. That was established, as you rightly mentioned in the case. It was established that she used it as prescribed. So the issue of whether she didn't use it as prescribed, that one did not arise at all. It didn't arise at all. I know that if they give a drug prescription to you and you did not follow that prescription, you can't come back and say that it didn't work. That is a different thing entirely. And then of course the issue was, the most important thing there was even the fact that whether she was entitled to that £100 that was to be given to her from the £1,000 that the company claimed that they deposited with their bankers. So now, let's go back to the case. So the point here is that, which is important for us to know here, that I want all of you, just what I'm saying here, that so that you can, this case will be part of you. So I just sample so that people will read it and then understand it very well. Now you will see that an offer can be made. What they want to say that this case has so many principles, and we're going to see subsequently. Even the question is whether advertisement. You are all into business. You are businessmen, MBA, Masters in Business Administration. You are involved. So when people advertise for services, advertise for contracts, advertise for products, advertise all those things. Are there offers? Because remember that even like job for those that are working in human resource persons, when they advertise for a job, is that advertisement an offer for employment? These are things that we want to look at it from because that's how relationship usually starts. So this case is saying here, if you look at the case, if you read the case, they are saying that, look, this was a unilateral contract. Because I said, there are different types of or categories of contract. A unilateral contract is a contract that's made by one person. Ideally, we have a situation whereby you have the offeror making offer to the offeree. So two persons. But where they are so in that contract, you call it bilateral. Bilateral because two parties are involved, negotiating to each other. Now, but where you have is when you have a situation whereby one party did not negotiate with the other one, but just made an open, when you say advertisement to the whole world, you didn't have someone that you identify that you are going to that contract with. So what Catholic Small Company were arguing was that, look, we say any member of the public. So we didn't have mentioned Miss Callis, so that she bought something, the drug quality, right? But then the offer was not made. There was no offer. The offer was not made to her because, according to them, they would have mentioned her that, look, Miss Offer and things like that. But she wasn't mentioned. They just say that any member of the public, and it's vague. When you say any member of the public, is vague because don't know who exactly is member of the public. So, but the court have to say no. An offer, can be made to a person, a group of person, or to the entire society, to the public. Now, usually to the public is what they call unilateral contract because only one person makes the offer. The other members of the public don't have obligation to do that. But you know that if it's a bilateral contract, supply me books, I will pay you. If I supply, you pay me. But if we just advertise to the public, members of the public have no obligation to comply with the advertisement. They may buy, they might go into it, or they might not. Right. So first of all, they said that one was said that no, yes, they overrule Catholic Sumbocom by saying that look, you can make offer to the public at large, not just one person or two or person, as the case may be. And of course, even the issue of advertisement too, you can also see that. So from that, you can now go down to we're going to see advertisement subsequently. Now, from there, you can also see what they call elements of valid contracts. Now, elements of an offer. We are saying that an offer must be definite, must be certain, must be unequivocal. Otherwise, it will be regarded as invitation to treat. Now, as I said, in transaction, in negotiation, in bargaining, or in going into a relationship or contract, commercial relationship, there are many layers to it. Imagine, I don't know whether you have an experience whereby you are pushing a project, you go for meeting, you go for meeting, another meeting. In fact, some people, when they are pursuing projects, they hear that one of the companies abroad, they will charter a private jet, meet that person in that place. I know many people that they fly to country, if they hear that Tinubu is going to one country, before Tinubu reach that country, they're already in that country waiting for Tinubu because they're pushing one contract at federal level. So there are many things involved. And I'll give you an example of when University of Lagos, before University of Lagos gave you admission later, you went through a lot of things. Now I said that all those preliminary stages that led to the admission are called invitation to treat. So when University of Lagos send notice for, they are not offers themselves until this is. So now we're saying it must be definite. It means that expression which amount to preposition, or that statement, or that oral statement, or that it must be definite. Definitely in the sense that you are saying something that is within your mind. So it's manifesting. It must manifest in such a manner that the offeree will not need to ask further question to know what you mean. When you say make a statement and it's not clear, it means that the person will need to ask you more questions before understand. That means that statement cannot amount to an offer because it's not definite. It's not certain. You need more inquiries to understand what it means. So I'll give you an example of Luko and Mbanefo. Mbanefo is a car dealer. Assume that she's a car dealer, and then she's dealing with SUVs and all of those ones. So if Aluko Olumide say, "Oh, Mbanefo should supply him Toyota," let's say Toyota SUV. Let me just mention the company SUV, Toyota SUV. That is a statement from Olumide to Mbanefo. So is that statement, is it clear or is not clear?
Not clear, sir.
Okay, good. What is not clear about it?
I'd say that he didn't specify the amount, the number of cars, the number of cars or the year of the make of the car, or it wasn't. There are a lot of things that are not specific about his request. He just said supply
Good.
data.
Good. So you see that a statement has been made quite right, but you see that you need to start asking him question again. Which year do you want? Which color? Which make? What are the features do you prefer? All of those ones. So there are many questions that remain unanswered. It means that what Olumide have in mind that want to express to Mbanefo is not clear. It's not certain. So that cannot amount to an offer because it's ambiguous. So, but when you make that statement so clear, then those statements that comes from Olumide to it becomes an offer, and those are the terms of okay, I'm supplying this certain number of cars. This is the color that I want. This is the year that I want. These are the features. So when you pick it, what you are supplying, you ensure that it complies with the terms of that, and then it becomes acceptance. So it has to be, because if that statement, for instance, now that is not clear, it means that it simply amounts to invitation to treat. They are just at the preliminary stages, not offer at all. Another element of an offer is that it must be, must be the offeror must be willing to be committed to the offeree as soon as. So it means that one offer, of course, that offer has to be, that case, all these cases I'm giving here, they're online. You can always go online and check them as the case may be. So another element is that the offer must be made by a capable person. That's why I was telling you about the issue of value capacity. You must have capacity. For human beings, it could be age. The person of age, in child right act said that look, any person, a person of uh, uh, 18 years and above that can go into a valid contract, things like that, right? So, and then even though the age varies for different contracts. Like University of Lagos, for instance, University of Lagos admission for at undergraduate is 16 years. It means that someone that's 16 years can enter into an agreement with University of Lagos over that certificate that is there. But other contracts is 18 years, as the Child Right Act, provides. So it varies. For companies, the capacity of company, you can find it in the memorandum. There's what they call the object clause, or the purpose for which the company is formed. So, like University of Lagos, for instance, is also a person, and so University of Lagos is a person, and of course, what I mean is that, um, uh, you know, the capacity of the University of Lagos, you can find it in the law that established University of Lagos. If you go to Zenith Bank, there's a memorandum that there's an object clause where they say, oh, this company is established to deal with financial, services and things like that. So you cannot give a contract to Zenith Bank to construct or repair Third Mainland Bridge, because if you look at the object clause of Zenith Bank, you can't find engineering, construction of bridges, and you can't find it there. So they don't have capacity to go into those contracts. So what I would say, was saying it because where you are working as business persons, when you go into any contractual relationship, you find out whether those persons have the capacity to even negotiate with you before you even proceed. And so the person that, if someone makes an offer to you, don't just be so happy to accept it. Find out whether the person that even gave it, did the person have the capacity to even do that in the first instance. That's why even you are writing on you always say that on behalf of the company. Know that, even you don't say on behalf of the company. Once you use company, they like paper and things like that. There are presumptions, even though sometimes those things may be forged in the exceptional cases. But the communication has to come on, legislative papers and things like that. So the offer must be made by someone that have capacity, and then of course, must be communicated. I said that before. Must be communicated. Communication. You have something in mind and you want to exchange with another person so that that person accepts is binding on you. It means that you must manifest it. You must communicate it. So if you have intention to enter into a contract with somebody, you keep it in mind. There's no human being is so super to know what goes on in another person's mind. No, nobody. It's only God that knows what goes on in someone's mind, right? So these elements are quite important to a business person because you go into negotiations on daily basis. So not everything that someone say in the course of your negotiation will amount to an offer. No, it's at a point whereby it became so clear. Nothing is. So it could be that in this scenario now, if the question, the expression that come from Lumide to Banafo, for instance. Now, in responding, Banafo now raise question. No, that we have this is the car that we want. This is the one that we have. And we are selling only one. This is the price. This is how to supply it. So if now Olumide now accepts, it then means that You see, at that moment, the person that makes the offer is no more Olumide, but it's Mbanafo that was making that, because from what comes from him was definite, not what came from Olumide initially. So, but if this one too, always say no, this is not this type I want. I want this one. It means that, he's saying it's more clear now. He has accepted with the terms of this guy, but then he changed the color. So you see that the color that I choose now, the one that was said by before is no more valid this again. Is the one that will be there. So sometimes you keep exchanging this communication until when one party did not, it becomes certain to all the minds, then the other parties will accept that the contract comes into existence. But all other ones that you are countering yourself, they are not valid at all. They are not valid offers at all. They are just invitation to treat. They are just preliminary stages that you are going into. So that's, having said, it becomes also now important for us to understand the difference between, look at it closely, the difference between invitation to treat and an offer. Do you have any question before us continue here? The difference between invitation to treat and an offer. So, it's always said that, look, it's not always easy to distinguish between an offer and invitation to treat, because an offer will not dress with a clothes or with a signpost saying I'm the offer. This is the offer. This is acceptance. You can't find it like that at all. Cannot. So how do you now go about it? So it's difficult to do that, but then over the years, decided cases, the court have tried to demonstrate instances whereby in a scenario, you know, it can tell you where invitation to treat starts and where an offer began. Now,
Hello,
one more.
Hello. Can anyone hear the lecturer?
Yes, you can hear him.
Okay, somebody not hearing me?
Can hear you, sir.
Okay. So, one way of this thing, for instance, there are many of those instances that you can distinguishing. But one of them is tender, bid. When there's advertisement for a tender or a bid. I know you should understand what is a bid now. When government advertise for tenders and bids and all of those ones, I guess you know. Or companies advertise for bidding and all of those ones. I hope you are aware of all those ones.
Yeah, sir.
Good. So the question here is that when this advertisement for bid, the bid, they will list the company advertising for bid, they will list all those things. This is what they want to do. These are things that if any person is have the requirements, you apply and all. So you see all those details, and then Her Excellency Mbanefo, the governor, now will respond. And then so you have the bid that was sent out, and then you have responses. The bidded, those other ones that bid that people submitted in response to that tender that was done. So you have two set of documents here. One, the tender is said that was either published in the newspaper, and the response, the bid that was submitted. You have two documents. Now, if you put these two documents side by side, who is making an offer? I'm asking the question, who is making an offer? Hello?
Side by side.
Hello, who is making an offer?
It's the company making the offer.
The company makes an offer when it's sent to the public, the tender, requesting for tenders.
No.
So who exactly is making the offer?
I don't know.
I don't think anyone is making an offer because there was no contract, right?
You are lawyer, so wait, no, there's no contract. We know now. Contracts start with an offer. Every contract starts with an offer. But you know,
The
offer will not
public
address it.
makes
So,
the offer. When the organization publishes its tender to treat, so the company, those buying the shares, for instance, if they are publicizing for the shares for
yes,
individuals, the general public to come and buy shares from their company, that's
yes,
invitation to treat. So when I want to buy the shares, that's an offer.
okay. So even so in tender, okay. So any contrary view to this, any contrary statement. Did anybody think otherwise? This class is too quiet. Oh, he said they cannot hear the lecturer. Who is saying that? Somebody, Obafemi. They tell Obafemi to off his phone because people are hearing me now.
Guys,
The bidders make even Louis Emit saying that the bidders are the ones. So that means some people are hearing me. I don't know why he's saying that he's not hearing me. Maybe it's on his own gadget or something. Maybe he can off and enter the something again, right? So we could see that you see in a typical scenario, for instance, you know, in those areas that it is the bids that are submitted that are offers, and so because you could see details of a bid, all everything, those details are there. So it's not left for the a company that you know that published the tender to either accept or so you can choose any of them and accept. So even the sale of shares, for instance, you know, when you subscribe, when shares are advertised in the papers and you subscribe, those subscriptions are the offers. So it's not left for the company that has you know have offered the shares to for sale to accept any of the subscription or not. You know, if they reject, they can return your money back. You know, as the case. I mean, as the need arises. So that's one. That's one example to demonstrate the difference between to know at the stage where there was invitation to treat, or and then also know the stage where an offer is said to be made. So another example is where you display goods that are displayed in the supermarket, shop right. If you enter shop right, goods are displayed. If you enter pharmaceutical store, drugs are displayed. If you enter boutique, clothes are displayed. If you enter market, those things are displayed. If you go to food market, food are displayed. Now, who is making an offer? So a customer goes in and picks whatever he wants to, and then they negotiate it, and then the goods are bought, and you go as a customer. So between that customer and the dealer, the seller, who is making an offer, and at what point is offer made, and by who? Another question: Buki Oni or Buki? Buki Oni. You're displaying here, so that's why I said that. As you want to give us the answer, Buki, is she here? No, she's not here. People log in and then disappeared. Yes, any response? Any response from the floor? Any response from the floor?
I think at the points when the customer, somebody is trying to talk.
Okay,
Precious.
so I was.
Precious says
Mhm.
the seller is the one making the offer by displaying the goods. Okay. Yes, let me hear others.
So it's in shop right now, the goods that are displayed are invitation to trade. The people going to buy, they are the ones making the offer.
Why? So, okay, so explain further. Why is it that when you pick the goods that you make it's deemed that you make offer?
Yes, because I can decide to get there and they decide not to sell to me. It's an invitation to the general public, not to anybody specific. That okay, we have this for sale. We have also varieties for sale. So out of it, I pick out of the varieties. Okay, this is the one I want, and I make an offer to pay for it.
Okay. So just to add that it is offer because you know we said that offer one for you to understand it, just test it against the element on the offer. One of them is that it must what? Definite. It must be communicated. It must be definite. So you see, if for example now goods are displayed, millions on plus goods are already displayed in the shop right. So if you say that the shop right is the one making offer, is making offer in respect of which item? You understand? That's why the display cannot be. But once you go and pick, once the customer picks, so it becomes very certain, very clear, unambiguous that, oh, this is what. So what you have in mind has been manifested. It has what? It has manifested out now. Oh, this is the item that you want. So when you pick it, you are the one making offer. Now it's not left for ShopRite to accept or reject. So you may pick some goods and say, no, we're not selling this one, or this and that, and they will stop it. They will not sell it. So that will consider where the offer at the point that offer is made. So when you see goods are in the market at display and all of those ones, somebody said low is upside down, or low is not upside down. Somebody said low is upside down. That's why you are learned.
Ask a question.
Yes,
my understanding was that so after it was ShopRite that made the offer that, okay, this is the amount I'm going to sell this to you. But what you explain now is the customer who is going to pay now that is making the offer.
Exactly. Because
I
there are too many
thought
goods.
at some point in offer that okay.
There are many goods in the ShopRite.
Okay.
There are many goods. So you see that's element of certainty. You know that offer must be certain. The offer must be certain.
Yeah.
So if you display goods now, so which of them are you selling to me? So assuming that you are, even if I enter in as a customer, you as a ShopRite, which one exactly are you selling to me? So I should buy everything in the shop and go? It's not possible. So there's no. So that's why offer must be. It must be certain. That's why. Yeah, even the car. You said that. Oh, it didn't tell you this car. How many cars? Which color? Which year and things like that. So that's why we're saying that it is because once the customer pick, then this element of certainty is now become definite, clear that this is what the offer is to buy the fridge, the offer is to buy the deep freezer, the offer is to buy the smart screen, the offer is to buy your bicycle for your daughter. The offer, so you could see that once you pick it, it becomes very certain. So it means that expression, so it's the customer that makes that offer and not the it makes the offer how? By picking that item.
Okay.
That's where the offer comes in. But once you pick that item and comes to the counter, that is where offer is made. But even if you go inside and walk round and come out, nothing, no offer has been made. It's still within the realm of invitation to treat. You are just still at the preliminary stages. So you can go in, go out. You go outside, you change your mind again, you come inside again. You come inside again, you go out, you come inside again. And then you have to pick one item. You know that sometimes you want to but you go to this shop, as our ladies used to price like that. You know, the men will not price, they will not buy. Our ladies say they'll go to this shop, they'll go another shop, they'll come out, they'll go another shop, they'll come back to the ones that they've gone before again. And then I don't know whether it's true or excellency. I don't know whether it's true. So you see that. So another one is that Henry, I'm coming. Another one is another instance where the goods where you using your ATM display of ATM machine, right? When you want to withdraw money, maybe 100,000, 1,000, irrespective amount. Now you passing by, you see light, one machine displaying that light there. You ask to insert your card, you put in the card, display some, then you start, information will start displaying. Is it current or saving? Put this one. Is it which currency? Do you want to recharge? Do you want to transfer? There are so many questions. You just pressing until the press and then the money comes out. Now, in that chain of ATM machine, at what point an offer is made? Is it the bank that makes offer, or is it the customer that makes offer? And at what point? Hello?
I hear you, sir.
That's an invitation to trade.
So everything you are doing in life, everything, even the food you are buying, when you go to buy fuel, contract for sale of that fuel, law is watching you. Whether you are conscious that law is watching you or not, law is there watching you like this, even at the point of buying your fuel. The fuel station seller, fuel seller at the fuel station, and you that's buying the fuel, who was making offer, and who exactly was the, so who was the offerer and who was the offeree? This is what you must know. It's a must. because every contract starts with an offer. So fuel attendant, is it fuel attendant that makes offer or the person buying the fuel? Who is the offerer and who is the offeree? In the
So
banking,
should we just see it like the other way around, that okay, when it's the person coming to get the product is the one making the offer, and the person giving the product is um the one receiving the offer. I don't know if I'm seeing this in the right light.
no, it's not static like that. It's not, law is not 1+1 2. It's not, law is not 1+. So it could be that when you pick that item, if you enter into supermarket, into shop right now, by picking that item, you have become the offeror. ShopRite become the offeree. Now, but if you go to that counter now, maybe even the price is on it. You go to the counter, they say no, the price that is on that item that's not the price they're selling. They're selling, the price has changed. At that moment, ShopRite have rejected the offer, and the implication of that rejection is that, look, that offer you made has been cancelled. It's no more alive. It's dead. It has been rejected. It's dead. So it's the new statement from the ShopRite that becomes the offer. So ShopRite at that moment become the offerer. You become the offeree. So in the same transaction, you pick the item. At that moment, without anything to it, you are the offerer. You took it to the counter. At that counter, they say, no, the price has changed. That moment, it means that it wasn't accepted. And so there's a counter offer. There's a counter offer from the ShopRite now, destroying that your own. So the one from ShopRite become a new offer. So it's not left for you to accept or reject. If you reject, you can just walk away. Say, no, that's not the price. I'm not buying. You walk away. That means that you have rejected the new offer that has been placed. So you see that in one transaction, you, the customer, can be an offerer, or ShopRite can also be offerer, depending on how you are throwing back. No, I will not. Okay, take if the ShopRite says is 100,000, it has increased to 100,000. You say no, you have only 90,000. You have counted one for ShopRite again. You become, so you see that is their chain. People go into business, they are not doing this freely. In fact, if you want, when you after this lectures or tomorrow, go to any superstore and stand there and fold your hands and just see, you'll be observing things. Or go to any market nearby, Yaba market. See people who come and hold clothes like this. Price, drop it. You just be observing elements of contract in the market. You just be enjoying yourself. They don't know what they're doing. See, we're busy waiting contract. Those guys don't know what those things are talking about. They are busy doing it. But inside it, contract is going on. Elements of contract are being negotiated. They don't, without them knowing. Or is it issue of transport company movement, BRT? BRT at the bus stop. You have also gone to the bus stop. Between the passenger and the BRT, who makes offer? What are they?
Elisa,
Yes.
I feel the passengers are the one making the offer.
So if one making offer, once the BRT stop, you must enter because they accepted the offer. You must enter.
I feel the fact that they pack and they can actually reject not to pick it.
So you see, so it's not that static. It depends on the. So it's not static. It keep moving until the point that okay, no, I'm not okay. In fact, in the days of the downfall, that one is even more interesting. The winter they say, madam, the price has changed, or you say, no, stop, let me come down. This is very important because imagine now you enter downfall from University of Lagos to Ikeja. Now you enter the bus. The downfall they didn't say anything at all. Now, once you reach Anthony, you say, no, you have changed your mind. You don't want to go again. And they say, bring money. Say, no, you are not more going to Ikeja. They should drop you at Anthony. Well, that is why you start speaking. You will speak contract higher. That there was no offer and acceptance. Okay. You speak that one tire. Okada man carry you from this enter that place. You're telling one malam say, no offer and acceptance. Did I say you should take me? Do you agree the price, negotiate the price with you? You are wasting your time. It will just useless you there, embarrass you, and things like that. But I'm saying that in all of these situations, there's that element of contract inside. So anything that you agree, yes.
Oh, sir, yes, my hand has been up. So thank you, Prof.
So a bit more.
Yes,
Okay.
Prof. So my question is, in the situation of maybe public companies that issue shares, they make public offers, and let's say I subscribe to their shares, what would I be called? Are they the ones making the offer, or it's me that is subscribing to the shares that is making the offer?
Yeah. So when you subscribe, when you subscribe based on, so first of all, the advertisement that they've done is invitation to treat. They are not offers. That's one. Now, when you subscribe, now it becomes certain that, oh, you want 10,000 shares, you want 10,000 shares, and then you even pay to the account that they say you should pay, as the case may be. So at that point, you are the one making those things. So now the bank, what the bank at that level now is that, because you are express, that's offer. If they accept, they'll keep the one and give you share certificate. But if they can also reject, and sometimes they give one excuse that, oh, the shares has been oversubscribed, as the case may be, or they will bring one other condition that is not part of it. In that case, you see that. So it's not
Sorry, sir, I
static.
want to ask a question.
Just hold on one by one. So it's not static. Not as if the situation will remain the same. The issue is that we are looking for where the two minds come together. So it's only at the point that something became very clear, and the one also accept that is where two minds were saying that two, because contract exists where two minds come together.
Okay,
Right?
it's when the two minds come together, that's when you can now determine who is making the offer.
Exactly. That's the point. That was okay. Oh, at that point, who was the last person that did the expression that you accepted? That two minds come together. That's when you know who is the offer. So it keeps swapping, but you can always know at the point where the two minds can come together because they don't understood, oh, this is what is involved, this is the contract, and then we are set. So it's not that static that you just no. So sometimes it could be the subscriber, it could also be the bank that's making those things. But this is just at what point can we say that the certainty and other party have accepted what the other one says. So that is it. Yes,
okay,
Henry.
thank you.
Yeah, thank you. Yeah, someone that was calling her. Is it Henry or what do they call it? There's a
It's me,
guy
Henry,
that.
sir.
Good. Well, can we hear you?
Hello,
Madu.
sir. Yeah, it's me, Henry. So,
Madu,
sir,
yes.
I still feel very strongly. Yeah, I still feel very strongly that in the case of complaints offering public offers, the ones offering the ones are the offerers. Why the public, members of the public that subscribe are the offerees? Because several years back, I did a lot of things with the capital market. And I can really say for certain that when a company comes out to the public to say we're offering, like last year, Zenbank, was it okay, early this year, Zenbank came out with some public offer as one other banks took when they needed to raise some capital. Now, when amount of money has been earmarked, for example, they will tell you 50 kobo ordinary shares of 1 naira ordinary share is now being sold for 30 naira, for example. That's a consideration. And they will tell you minimum of this XYZ shares can be bought. And also they always give timeline when the public offer will end. Usually at times they can extend if they do not reach the targeted subscription they want.
Yeah.
So at that point in time, sir, it is a contract because the considerations have been placed. There is a timeline, sir. There is a timeline already. And the person bringing out the terms, the people bringing out the terms are the public quoted companies, not the public, sir. So the public's own thing now is either to agree to say, okay, I want to buy 10,000 units based on the amount, for example, Zenbank wanted to sell. So that's a contract. And so the offeree is the public, sir, and the offerer is the bank.
Okay. So let me ask this question now. If assuming that you are the one, Henry, you are the one buying the shares, right?
Yes, sir.
Okay, let's assume that you are the one buying the shares. Now, if Zenbank, if Zenbank have issued out prospectus for calling for purchase of shares in their own shares now, and
Yes,
you
sir.
are the subscriber. Now, if you are saying that you
Yes,
are
sir.
the offeror, how many shares?
The offeree. The Zenbank is the offeror. We are the offeree. So if at the end of the day, Zenbank plans to
Listen
sell
now, listen,
maybe
calm down,
$2 billion. Okay,
relax.
go ahead, sir.
Relax. if they say 10 billion shares, if the issue the issue is for 10 billion shares or 100 million shares or 500 million
Yes, sir.
shares or 1 billion shares, right?
Yeah, I'm with you.
This is what they will say. Now, why it cannot be, why their own this thing cannot be offers, because how do you know? How do Zenith Bank will know that Henry want to buy all the 10,000 or we want to buy only 5, we want to buy only 1? How?
Let me explain more. Sir.
Sorry, there's a noise. The
When you see
class
what
is
you
going
food
on.
for,
Please
yeah.
mute people that are making noise there. There's noise there in the background.
Yeah. Now let me explain further. Now,
No,
let me myself respond now.
hold on. See,
Okay.
it's a law. It's a law. This is guided by law. So it's a law
Yes,
that
sir.
says that look, it's only when X, Y, Z happen that you have E or T. So when this happens, you have to test what they test it against.
Now let me answer you,
Hold
sir. Now
on,
let me
hold
answer
on.
you.
Now we're not fighting. You are here to learn. You are here to learn.
Yes, sir.
Just relax. See, we are saying that. Let me just give one example. That one element of offer is that the offer must be certain, must be clear. So if General Bank, issue out prospective for some number of shares, even if it's not to you, it's public that they issue to. Now, why that cannot be? They are not offer at all. Because they are offering, offering to who? And how many number of shares? Let me just ask that question. How many number of shares? So it's only you. It's when you decide, okay, going by this 1 billion shares, let me just take 100,000 shares from it or 1 million shares from it. At that point, it becomes clear that it's you that is not that want to subscribe to only 500 or 1 share or 2 shares. As the case may, it becomes very certain at that moment. Because one element of an offer is that it must be certain. That expression must be certain. So if they say subscribe, public should subscribe. So it's not binding. So what happens if no member of the public now respond? So it is the public that subscribe, and that's why once you subscribe to shares, it's not over because the bank are not bound to accept. They can reject your money and return the money back to you. I mean, they rejected what you offer to buy. It's as simple. Because it's when you say, oh, I'm subscribed to 10,000, 5,000, or 5,000, or 1,000, or that it becomes certain from that 100 million that was, or from that 1 billion that was, advertised to the public. That's how it is. So, but if we say that, the customers are offering how? Because the bank, you don't even know who and who is buying. And then even if you know I'm buying, if I know that Harry is buying, it's only when you do that I will know. So what happens if it's 1 billion and you buy you subscribe only to 500 million? It means that wasn't it. You have counted what they want is 1 billion. It's only 500 million that you picked. So it's only then that becomes certain. It became clear that this is, and is that element of certainty is a fundamental requirement of an offer. So if in a transaction you are negotiating, and there's still very element of uncertainty, it cannot be offer. No matter how deep, no matter how well you are discussing it cannot be, because there's still element of ambiguity, uncertainty. That's what the law says. Henry, you can unmute yourself and respond. Yes.
Now, like I said earlier, sir, like we're all learning. Now, why is it said I still maintain my standard? The customers, the public are the offerees. You see, when a company, like I will still use Zenith for example, but I did extensive work with them several years back. Now,
yes,
you see, when a bank issues a public offer, that's why it's called a public offer. A public offer is usually done, it's usually advertised in print media, internet now, one-on-one. You go to the banking house, the customer advertise it. But when you go to the floor, and tell your stockbroker that you want to buy, that time you are the one is offering. You are the offerer at that point in time. But when it has to do with the public offer, that's why it's being referred to a public offer, whereby the members of the public are free to buy whatever their monies can afford them.
The general rule is that
yes, hold on, sir. So at that point in time, sir, can you hear me, sir?
Let me. So by the time we go further in the contract, it will answer you. But let me just correct this impression. The general rule is that anything advertisement is not an offer. That's what the general rule says. Anything that you're advertising is not an offer. So you need there are some things that need to yes. So on there are some things that we need to add to it before you convert that advertisement to an offer. So once you advertise for sale of shares, general as law is concerned, that itself cannot be. Once you're advertising, that in itself cannot be an offer. And that's why you see that even in Cali and Cabo Single Company, the court said, look, the person did not only advertise, he went further and said, look, I've deposited 1,000 pounds with my bankers. That was what they used to qualify that, okay, because it was an advertisement. Ordinarily, the advertisement would not be an offer. But because you assured the public, look, you have deposited X amount in the bank with your bankers for compensation. So at that moment, it moved that advertisement to offer. Because of what? Certainty. But the rule is very simple. Anything advertisement, once you are purchasing anything, once you see an advertisement, Henry, the law is saying that, look, that person advertising is invitation to treat. It's only inviting you. Come, let's negotiate. It's never an offer. That's what the law says.
Okay, sir. Thank you.
Yeah. So, and because there's a point that I need to make before we go. So you people go and negotiate that one now. The one on the ATM machine. I want to go tomorrow. You just go and observe that, or go and observe something in shop, right? And tell me what you observe, and then you always tell me that at the point that who makes an offer, and then of course, and at what point was invitation to treat, and at what point is an offer. And of course, one fundamental effect of invitation to treat that is not an offer, so you cannot accept invitation to treat. It's only offer that can be accepted. You cannot accept, so it's like nothing, so you cannot build anything on it. But an offer is the beginning of the contract, so you can always build something on it by accepting. So one last thing before we end today is termination of an offer. How the life of an offer can come to an end. Termination of an offer. So there are many ways the life of an offer can come to an end. I know you know it as lawyers. My own duty is just to remind you, because you are all learned colleagues. And then what are those ones? Revocation. Number one is what? In no particular order. I'm just mentioning them. One is revocation. Revoke. Revocation is spelled REVOCOTION. CATION. Revocation. When you withdraw. So the offeror, in the scenario that was pointed, whether the customer or whoever is making the offer, as the case may be, you make an offer, the offeror has making, but before that offer is accepted, he now withdraws it. So when it's withdrawn, then of course there's nothing again to accept. The life of that offer has come to an end, right? So there are many ways. Many ways. Offer has made an offer to Henry for supply of what do you want to supply here? It's the same cars or truck or fertilizer or anything. But before Henry or Madu will accept, before we accept the contract or the offer, the manufacturer have withdrawn it. You have withdrawn it. And there are many ways. Once you withdraw, you also communicate that, oh, please, so I made my mind. Don't bother again. Don't bother again. That has been done. Don't bother again. Oh, okay. You are thinking you wanted to but you are not made your mind. Okay. Oh, sorry. Don't bother again. It means that you have withdrawn that offer before it's accepted. It comes to an end. Or by rejection, where the offer is made to the offeree, but the offeree rejected. Rejection can be orally, can be in writing, can also be by conduct. Rejected. And of course, I give you an example of, someone has an example of, offer by conduct. You enter into a eatery, you didn't say anything. They gave you food, you eat. They gave you rice, you eat. You give water, you took, and then you want to go away because there was no offer. You didn't ask for the rice, but they gave you eat and things like that. You can't do that now. If anybody can do that tomorrow morning, anybody should do that and should come and tell us. Gospel, you can try it tomorrow and tell us the result. Enter any eatery. Don't say anything to anybody. Sit down. If they give you food, eat. Give water, take. Then start going out. And then when they stop you, tell them that was there any offer and acceptance, and then just observe. Tell us what will happen thereafter, and come back and report to us next week, Thursday. Gospel, Dozie, can you do that for us?
They will pound me.
Don't worry. It's like when they now become serious, tell them say in a prank. Now class now you are testing what they teach you in class. That is fine. So it can be rejected. And also the life of offer can come to an end by death. So there are some contracts that require personal performance. Contracts like this education that you are doing now is personal contracts. So if anything happen, God forbid, anyway, if anything happen to you, you can't say that your sister should come and continue, or your brother should come and continue for you, or your parents should come and continue for you, because it's a personal contract. So it's only that contract that can survive your estate that you can say that you can accept. Otherwise, if offer is made and the parties is dead, either the offer or the offer is dead, and of course, once it's personal contract, that offer comes to an end. The other one is by lapse of time, where offer is made and the time is stipulated within which you have to accept, and then you do not accept within that particular time. The life of that offer also will come to an end. So, ladies and gentlemen, of course, these are the areas that that I need to bring to your attention. There are many other ways that an offer can come to an end. I just mentioned those ones for the purpose of your knowledge. They are not exhaustive, right? Okay, so Learner colleagues, any question? It's 8 o'clock. Time fast spent. Time fast spent. It's 8 o'clock. Any question?
Yes, sir. Good evening, sir.
Yes.
Please, I raised hand up before, but
no, I can't see it now. Maybe you
yes,
raised and took it down again.
Yes. So I want a little clarification, sir. My question is this:
Who is speaking? Barrister who?
I'm Barrister Dozie Goswell.
Okay.
Yes, sir. So are there circumstances, because we see the dynamism of offer and the rest of the whole thing, but I want to know whether there are some.
Yeah.
Yes, are there some circumstances where offer can be a kind of static, or can you give us a kind of situations whereby an offer can be static, or maybe this conditional offer must be static, or this conditional offer must be dynamic?
No, like I give you example of University of Lagos, for instance. Now, when the university offer you admission, for instance, admission letter, that offer or appointment letter or some of those things, that has to do with those ones. You will see clearly this will offer you this job. Please, this is within your so please you have to accept within 2 weeks and things like that. You see that it's very clear. It's very clear. Even admission letter too, you see all those ones are very clear. You can see it. So there's no room for you. There's no room for you to start negotiating. So if you not write to that your employer and say no, I love you. I like my appointment, the way you give my appointment and this and that, but the salary is too small. I will only resume if the salary is so small. It means that statement that you made there alone have destroyed the life of that appointment letter that you have in your hand. So is this your new experience that becomes a new offer? So like even University of Lagos, just like there's no window for admission. When they give you admission, for instance, now you are writing University of Lagos, and that fee is too high. The university should reduce the price for you. I don't know. It's highly unconventional. Highly unconventional. But at least one example I can give is just admission for the offer for admission that you have. Even the one they have here, they call it provisional admission. Provisional admission. It means that what I mean is that it's not permanent. They can withdraw it anytime. That's why the certificate, university can use certificate that even if you die many years after, they can see, withdraw that certificate from you by pronouncement. Once they pronounce, even if you are having the paper with you, it becomes invalid. You can't use it in the public again. So I believe that is one example. There are many examples, but there's the one that I can give you.
Sir, with the example you just gave, what will happen to the money that was paid?
For what?
Will they refund it? I
Over
paid
what?
school fees. I went through the process. You withdrew the
Yes.
certificate.
Yes.
You return my school fees now.
So what about what I'm doing? What about the time what I'm doing here with for you? So you see that I also pay a price. One thing about this is that there's a price that you must have also paid. I'm ordinarily I would have locked you somewhere now. So from 6 to 8, I'm here with you. And it's not me that is here, it's because of Lagos that is here. So what do happen to this one now? Because the issue is that whether they withdraw that certificate from you, there are some skills, there are some things that you learn from this class that even if they take the certificate, even if you stop this program, there are some things that you're already part of you already. You acquired some things already. You can't refund those things. So there's what they call impossibility for parties to return to status quo. That sometimes that if that happened, that if it is possible for parties to return to status quo, for all of them to return, that the university will return you your money, and then you to refund all the knowledge that you acquire, everything back. Okay. So it's a different thing entirely. If it's the fault of the university, why is the fault of the university? Then you can ask for refund. Because in that case, it's a fault of. But why is your fault? And then what they've done here. What most of the chances like most universities, what they charge as school fees is very small. The other ones are okay. You add the card now. They give you ID card. How can you turn the ID card back and take your money? Exam fee or library. You use the library. How can you say they should refund the money to you for library that already used? You understand? So, Jolene, I don't know whether I answer your question. So this is the last person. Dennis is the last person. It's far after 8 now. I have to leave now. Dennis, you're the last person. Yes.
All right, sir. When you were talking about revocation, you mentioned that the example you gave was that if there's already a discussion to supply something in the company, for example, and the person later says, "Oh, don't worry," and all of that.
No, I say offer. I was definitely. I said offer. Offer was made for supply, but before you accept to supply, the offer will withdraw it. That's revocation. So revocation is on the side of the offeror, while rejection is on the side of the offeree.
Yeah, I'm saying the same thing, sir. Sorry. So, I mean, in the case where, for example, this is a company I usually do supplies for, and then they made an offer that I should, supply a certain thing, and then because of the trust that we've had over the period, I've gone to incur some expenses pending when we conclude the discussion so that I can supply. In that case, would there be a ground to, for them to pay those expenses that I would have incurred?
No, because the issue is that no, it's a different thing. Because if there's no acceptance, we can, there's what they call, when parties are negotiating and there's no contract yet, the general law is that the parties will always bear the costs. So if we're going for whatever cause that you are in at that stage, because there's no consensus, the two minds have not come together again. Have not come together yet. So it means that because you are acting, you only claim that someone is bound when the terms are. That's the definition of the offer in the proposition that local, that I will be contractually bound if you accept the terms that I'm offering to you. So if you are not accepting my terms, then you already start preparing yourself. That so it doesn't go that way. That's why in most cases there's a clause that parties will bear the costs of going to that contract. So, but once you go into the contract, you can always build that cost into the profit margin and what you want to charge that person as the cost of doing it. But you can't claim a right over a contract that over something that has never been entered into, where the two minds have never agreed on it. That's just the truth. And
Okay.
that's what we're saying, that you can't build, because once it is adjudged to be invitation to trade or preliminary stages, you can't build anything on it.
Okay. Then lastly, if we had a verbal agreement or verbal discussion, would that hold?
Of course, a contract can also be orally now. Contract can also be entered orally. It's only few contracts. There's only some contract that the law requires that it must be in writing. Like contract for sale of land or transfer of interest in land. The law requires that it must be in writing. Contract for hiring of seafarers. The law says that you cannot hire seafarers orally. It must be in writing. And also contract for guarantee. You want to guarantee someone for a debt, or the law requires that all of those ones require to be in writing. Right. So outside those ones that law specifically says you should be in writing, it can also be orally.
Okay.
It can also be by conduct. You might not even say anything by work. So assuming that even the one you're saying here now, assuming that you did not, they send those goods to you. You didn't, you send those goods to you assume that you are the one that sent the goods to them, because it's the old client. You send the goods to them. They didn't say anything, but they use those goods. Assuming that they are factory, they're into bread. It's a bread factory. You send the flowers. They've turned that flowers into bread, and they sold the bread. And now they say no, they don't want to buy your flour again. They will refund it. How can you refund it? Will you go to customers and get the bread one back and then regrind it again and convert to flour and then you turn back? No. So you see that by their conduct, even though they did not respond to you, by their conduct, it becomes late. So that sometimes that even this is done they can be adjudged that, even though there was no express discussion, no oral or written this, but the way parties behave themselves, in that case, they will use a third party, a reasonable person, a third party, looking at the transaction between two of you. They will now ask, would it be reasonable to say that there's no contract or not? So, they will not use your own subjective meaning. They will use an objective, approach to it, and then pass a conclusion. I know where you're coming. That's where the lawyer or the legal mind comes in, using the objective mind, and of course, the two tests for determining contract are also subjective test and objective test. All of those ones. We will learn them further as the class progresses.
Thank you very much. That's clear.
Okay. All right. So bye for today. Ask Lindsay. Any motion for adjournment? The court has to adjourn to another week.
Adjournment. What's that thing? Okay. Wait. Before you adjourn, please, are we going to get these slides?
Yes, you'll get it at the appropriate time. Because if I give you now, you'll be lazy. So I'll give you when it's appropriate. Yeah.
All right.
Court rise.
Yes, court rise. All right then. Cheers. Enjoy your weekend.
Good night, sir. Thank you.
Yeah. Enjoy your evening. Yeah.
You too, sir.
Good night, sir.
Yeah.
Don't take an offer for the slide, sir. Thank you, sir.